Lesson: Offer and Acceptance. In the realm of contract law, offer and acceptance form the backbone of contract formation, establishing a legally binding agreement between parties. Understanding the intricacies of these foundational elements is crucial for anyone aspiring to become a certified contract law specialist. This lesson delves into the practical application of offer and acceptance, providing professionals with actionable insights, frameworks, and tools to navigate real-world contractual challenges effectively. An offer is a clear and definite proposal to contract on specific terms intended to be binding once accepted by the party to whom it is addressed. The clarity and precision of an offer are paramount, as ambiguity can lead to disputes and invalidate the agreement. For instance, in the case of Gibson v. Manchester City Council, the House of Lords held that a letter stating "may be prepared to sell" was not a definitive offer, but an invitation to treat. This example underscores the importance of specificity in crafting offers to avoid potential pitfalls. A practical framework for drafting effective offers involves several key steps. First, ensure that the offer is communicated clearly to the offeree, as an uncommunicated offer cannot be accepted. Second, detail the terms explicitly, leaving no room for misinterpretation. Third, include a time frame for acceptance to prevent the offer from being open indefinitely, leading to potential legal complications. Acceptance is the unequivocal agreement to the terms of the offer, forming the contract. It must mirror the offer precisely, without modifications, known as the mirror image rule. Any deviation constitutes a counteroffer, which the original offeror may accept or reject. The importance of this principle is illustrated in the case of Hyde v. Wrench, where an attempted variation of the offer resulted in no contract being formed. For effective acceptance, professionals should follow a structured approach. First, ensure that acceptance is communicated to the offeror, as silence generally does not constitute acceptance. The mode of communication should align with any stipulations outlined in the offer. Second, verify the offer's validity at the time of acceptance, as offers can lapse due to time, revocation, or the death of the offeror. Third, document the acceptance process meticulously, providing evidence in case of future disputes. In modern contract law, the advent of digital communication has introduced complexities in offer and acceptance. The Electronic Transactions Act, 1999, provides guidance on this matter, emphasizing that electronic communications are valid for forming contracts, provided they comply with general contract principles. This includes ensuring that both offer and acceptance are clear and that parties have the capacity to contract. A practical tool for navigating electronic contracts is the use of contract management software. These platforms facilitate the creation, negotiation, and execution of contracts, ensuring that both offer and acceptance are documented and legally compliant. Additionally, they provide audit trails, enhancing transparency and accountability in digital transactions. The concept of the battle of the forms further complicates offer and acceptance, particularly in commercial settings where parties exchange standardized documents. This occurs when businesses use their own terms and conditions, leading to conflicts in contract formation. The Uniform Commercial Code provides a resolution framework allowing for a contract to exist even if terms do not match perfectly, provided there is mutual assent and essential terms are agreed upon. Professionals can address the battle of the forms by adopting several strategies. Firstly, conduct a thorough review of all exchanged documents to identify discrepancies. Secondly, engage in proactive negotiation to reconcile conflicting terms before contract execution. Thirdly, include a last shot clause in standardized forms, asserting that the final document sent before acceptance governs the contract terms. Statistics highlight the prevalence of contractual disputes arising from offer and acceptance issues. A study by the International Association for Contract and Commercial Management found that poor contract management leads to an average loss of 9.2% of annual revenue, emphasizing the need for precise and effective contract formation practices. To further enhance proficiency, professionals should engage in continuous education and training on contract law developments. Workshops, seminars, and online courses provide valuable opportunities to refine skills and stay updated on legal advancements. Additionally, consulting with experienced contract law specialists can offer insights into complex cases, fostering a deeper understanding of offer and acceptance intricacies. Case studies serve as invaluable resources for contextualizing theoretical concepts. For example, in Carlo v. Carbolic Smokeball Co., the court upheld a unilateral contract formed by a public offer and subsequent acceptance through performance, highlighting the enforceability of such agreements. In conclusion, mastering the principles of offer and acceptance is essential for effective contract formation and dispute resolution. By employing structured frameworks, leveraging technology, and engaging in continuous learning, professionals can navigate the complexities of contract law with confidence. The integration of practical tools and strategies outlined in this lesson empowers aspiring certified contract law specialists to enhance their proficiency and address real-world challenges adeptly.